Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial lawyer, and today I'm coming to you from sunny Florida, where I'm for the weekend after the Easter holiday. So happy Easter everyone. And I wanted to do a quick video about a case that just came down today, or rather the blog article. I just received it this morning at about 8 a.m. Today is Monday, April 1st, and I just received it in my email. And so it's basically a damages for a worker in a nursing home, a hospice type nursing home. And it was a slip and fall case, and it was a multi-million-dollar result, an excellent result, but the injuries here were very serious and life-changing as well. So let's get into it. This is a case from New York, and I want to say thank you to the New York Injury Cases blog, which is written by John Hochfelder, who's an attorney who, compiles a lot of these cases and gives verdicts and settlements for cases and writes a blog about it. So I subscribe to the blogs, that's how I receive the emails. So I'm reading his blog article, and I'm also reviewing the actual appellate court decision from the appellate division, and that's the source for this video. So let's get into it. So this happened in October 3rd of 2016, and it happened way upstate, I believe in a town called Williamsville, which is upstate New York. And it happened to a lady named Jasmine. So she was injured while she was working as a nursing home aide at a nursing care facility in Williamsville. And what happened was she slipped and fell, and when she did so, she struck her head on the hard floor. And this all happened in the patient's room. So she was a nursing home worker, she's taking care of a patient, and so she has this slip and fall in a patient's room, and it just had a hard wooden floor. And so she filed a lawsuit against the owner of the nursing home, as well as the nursing home itself, because it turned out that Jasmine worked for a separate company, which is often the case in these types of scenarios. An employee could work for a separate company, like a temporary agency, and then that agency will contract that employee to a specific nursing home. So she sued the nursing home and the owner. And actually, she was granted summary judgment as to liability, which is very rare in slip and fall cases. But in this instance, Jasmine was able to win summary judgment. Now, what that means is there is no issue of fact, right? There's no question for a jury to decide during a trial. Everything is so clear that as a matter of law, Jasmine is not at fault, and then the owner of this property and potentially the nursing home itself are at fault. And the way she was able to do that is that there was cleaning solution, and the cleaning solution was actually in another patient room that was next to the room Jasmine, Jasmine was in a room taking care of a patient, and there's a room next to it, an adjacent room. And so a guy's mopping in there, and he leaves so much cleaning solution that the cleaning solution seeps through the wall, under the wall, and it goes into like Jasmine's room. So she's just, taking care of the patient, doing her job. She slips and violently falls and hits her head against the floor. So the court said, look, there's no issue of fact as to her being at fault. Cleaning solution should not be seeping through walls or under floors into rooms that you're not even cleaning. You must have used so much solution, or you must have had some kind of problem with the walls. I don't know exactly what they said, but something to that effect, that it should not be happening. So then the case proceeded to a damages only trial. And it was in Erie County, which again is upstate. And the Erie County jury gave damages to Jasmine. Now, let me tell you about the injuries before I tell you the amount. So she was only 25 years old at the time of the fall. She lost consciousness when her head hit the floor. She was rushed to a hospital and admitted for 3 days, where she was evaluated and diagnosed with a head injury, blurry vision, decreased ranges of motion and pain in her neck and back, and then she was discharged to her home after the 3 days. But she followed up with a neurologist, and the neurologist diagnosed her with post-concussive syndrome, cervicalgia, headaches, involuntary jerking, which means like she's jerking, but she doesn't want to be jerking, it's just involuntary movements, problems with her memory, concentration, and vision. And this neurologist testified at trial that her brain and spine injuries are permanent. And she required a walker to ambulate, to walk. She could not walk without a walker for 2.5 years after this fall. And at the trial, she required a cane, and she testified that she still had difficulty caring for herself and her children. Her memory continued to be poor. She had not returned to work, and her treating physician gave the opinion that she would never be able to work again. Now, the defense argued that her injury was minor, especially in view of the fact that she sustained no fractures. An MRI revealed no bleeding or bruising of the brain or other abnormalities, and there, meaning the defense expert neurologist, testified that the plaintiff's head injury was minor and that her post-concussive syndrome and spinal strains had all resolved, so they all went away. You know, and it's just interesting, like the defense always makes the same argument almost in every trial, but you see, a lot of this is also things that people, like viewers like you, sometimes text me. You say, oh, I got into a car crash, but there was no fracture. Well, you don't need to have a fracture. A fracture is actually not worth that much. If you have a fracture, let's say of your, I don't know, of your metatarsal, and it heals, it's worth probably like, I don't know, 30, 40,000. But a brain injury is worth so much more than a fracture, right? Because a brain injury cannot, or usually does not heal. And that's the main distinction. So look at these arguments. The injury is minor. How could a brain injury where you have involuntary jerking, you have to use a walker for 2.5 years, how could that be minor? It's just absurd, right? And then they're saying no fractures, which, you know, okay, no fractures, but she has a brain injury. The MRI doesn't show any bleeding. Of course not, right? Because the MRI doesn't show the microscopic level. You have 84 billion neurons in the brain. The MRI is never going to show them because unless you have a 7 Tesla MRI, the MRI just doesn't show the microscopic level. The MRI shows more of the macroscopic. It doesn't go in that kind of detail. So that's why you need a 3T MRI with diffusion tensor imaging, or you need other types of neuroradiological testing. That's just a known fact. Like, it will never show it, right? It's just a known medical fact. So these arguments are really specious, you see. And now they're also saying that she didn't have bruising of the brain, but you don't need bruising of the brain to have a brain injury. And so basically, yeah, it's just, so let me give you a little inside information before I tell you the verdict. So here's inside information. In closing arguments, the attorney for the defendant argued that plaintiff's injuries all resolved within 10 months and that the jury should award her $100,000 for pain and suffering. That would be appropriate. And the plaintiff's attorney asked the jury to award $5,750,000 for all the pain and suffering. And again, that goes to another argument, right? They're saying that, and of course, this is not just the defense lawyer talking, this is the entire defense position, right? And how does the defense make a position? Well, they have a lawyer, they have an insurance company, right? That's the person holding the purse strings. And they also have experts, and they can choose to hire any expert, right? Any expert, whether it's a truly independent expert or whether it's a hired gun that they've used before, that's always going to testify for the defendants. And so the three of them, right? I mean, the insurance company, the defense lawyer, and their experts. And, you know, maybe they had more than one expert, probably, right? Because there's a neurological injury, there's some other injuries. They could have had 2 or 3 different doctors. So all these people, right? They came up with this argument that the plaintiff's injuries all resolved within 10 months. I mean, how could they all resolve within 10 months if she's in court with a cane, if she used a walker to ambulate, to walk? She couldn't ambulate without a walker for almost 3 years, right? It's an absurd argument. But what I like to do with that argument is I like to say this. Okay, so you're saying the fall didn't cause any of these injuries, but rather, you know, she just had injuries from the fall and they went on for 10 months. And then one day, just one random day, she wakes up. And on that day, 10 months after the fall, suddenly her injuries are no longer caused by the fall. They all just go away spontaneously, right? And now all her injuries that she has going forward on that random day, 10 months later, are all because of degeneration, right? Because of living your life. I got that argument from a lawyer, actually here in Florida, named Keith Mitnick, and I think it's a brilliant argument. Basically, you're saying, hey, it's all just a coincidence. I don't know if they argued that in this case, but they argue that so often in car accident cases, so I just wanted to share that with you. And here's the other piece of inside information, that there were several expensive medications in plaintiff's life care plan. So she had a life care plan, and the most expensive was Nurtec for the migraine headaches that she gets, which was estimated that all of these medications would cost $4,500,000 over plaintiff's expected lifetime. And the defense did not submit any life care plan. Okay, so now that we know the injuries, what do you think? I'll do a little, I don't have anything to clap on. I'll do a little, what do you think the verdict was? Okay, I'm gonna give you a second to give me your answer. Maybe put it in the comment below. Give you a second or two. Okay, in this case, the verdict was $3,972,701. And it broke down like this. Past pain and suffering was for 6 years, right? From the date of the fall up until the trial. It took 6 years to get to trial because the trial was in 2016. Past pain and suffering was $200,000. Future pain and suffering for the next 30 years was $200,000 as well. So the total pain and suffering was $400,000. Lost wages were $1,072,701. Past lost wages for 6 years were $177,290, and future lost wages for 25 years into the future were $895,411. Now, future medical expenses were $2,500,000, and that was for 30 years. So the big number was the future medical expenses. You know, I guess that's an upstate jury. They're a little bit conservative. I don't know how the case was presented. I'm guessing, you know, because most people present cases in the old school way. Probably, you know, the lawyer presented it in the old school way, and that's why they only got $400,000 for pain and suffering. I would have presented, you know, witnesses from her life, really painting a picture of how her life changed. 25 years old with a child. I think the biggest category should be the pain and suffering. That should be, you know, 4 or 5 million. And then, you know, future medicals is fine, but in lost wages is fine, but you know, the pain and suffering number should be much, much higher. 400,000 seems really, really low to me. Really, it should be a 10 million plus case, I think, with an injury like that. So now, you know, we've pretty much covered everything in the blog article. Let's go to the actual opinion. And so the actual opinion sheds a little bit more light. So if you're a real, you know, if you want to get into the nitty gritty and find out how these cases are actually handled, stay with me and let's read the actual opinion together. So yeah, it has the attorney for the plaintiff. Actually, the attorney for the one of the attorneys for the defendant was from New York City, and it has the attorney for the plaintiff. It was an attorney from Buffalo. I don't know these lawyers, but basically, it talks about the fact that, you know, plaintiff commenced the lawsuit where she slipped and fell at a property owned by the defendant, and the defendant, that's the landlord, right? Now, she also sued a company, an LLC, and the LLC was operating the nursing home. And so plaintiff was an employee as a hospice aide for a separate company, but she was on the property to provide care to a resident of the facility. And they said the cause of the plaintiff's fall is not in dispute. A maintenance worker employed by the nursing home, which is a defendant, was using a floor cleaning solution in an adjacent room, and that solution seeped under the wall into the room where the plaintiff and her patient were located. And plaintiff slipped on this cleaning solution. Now, she fell to the ground, she hit her head on the hard floor, and it caused her to lose consciousness. The primary dispute during the first 5.5 years of this litigation centered around the severity of plaintiff's injury. So they were saying it's just not serious. And so following discovery, plaintiff moved for summary judgment on the issue of defendant's liability, and defendant opposed the motion and cross-moved for summary judgment, dismissing the complaint, asserting a new theory that plaintiff was a special employee of the nursing home and that her claims against the nursing home should be dismissed under the exclusivity provisions of the workers' compensation law, sections 11 and 29.6. Now, you know, that's a good argument, actually. I don't know why they didn't bring it up earlier. I guess it was just bad lawyering, because yeah, if you're working for this company, but the company tells you, hey, today you're gonna go work at this nursing home, when you're in the nursing home taking care of the patient, wouldn't it be the nursing home, like the director of medicine at the nursing home, that controls the method and manner of your actual work, tells you what to do, what time to come, what time to leave? It's not like you could just show up at a nursing home as an aide and do whatever you what, right? You're not a true independent contractor. So if you're an employee, you could be a real employee or an employee, of the general employee of that separate company, whoever it is, but you become a special employee of the nursing home because you're there and they're controlling the method and manner of your day-to-day work, right? That's a great argument, and that a case could get dismissed on that ground. So the Supreme Court granted plaintiff's motion and denied defendant's cross motion, and the matter proceeded to a trial on the issue of damages. And defendants now appeal from a judgment upon a jury verdict that awarded this $3.9 million that we just talked about against both defendants, and the verdict was joint and several, meaning you pay whoever has money pays. It's against all of them. So now the appellate court agreed with the defendant that the court made a mistake in granting the part of the plaintiff's motion seeking summary judgment with regard to the issue of the nursing home's liability, but they further conclude that, contrary to the defendant's argument, the court properly denied the cross motion is insofar as it sought summary judgment dismissing the complaint against the nursing home. So what they're basically saying is that defendant's contentions concerning plaintiff's summary judgment motion and defendant's cross motion are properly before the appellate court, and they first want to address defendant's argument that the court made a mistake in determining that the defendants failed to comply with some kind of affirmation rule, and they said, look, that doesn't really matter. I guess it's some kind of statement of material facts, which is one of the things you submit with a motion, and somebody didn't do that. Again, I guess it was just bad lawyering on somebody's part, but they said that doesn't really matter. It doesn't affect the ultimate decision on the appeal. So they go, let's turn to the merits of the appeal, and they say, looking at the merits of the appeal, plaintiff's motion for summary judgment with respect to the issue of the nursing home's liability, we conclude, now this is the appellate division talking, the big court, the one that makes the final say on everything. They say, we conclude, although plaintiff established as a matter of law that defendants were negligent and that their negligence caused injuries to the plaintiff, defendants raised triable questions of fact as to whether plaintiff was a special employee of the nursing home, and as a result, whether her claims against the nursing home were precluded by this workers' compensation exclusivity provision, section 11 and 29.6. So basically what they're saying is, look, if you are working for someone, you can't sue your employer. And isn't the nursing home, maybe they could be considered her employer. So they said it's just a question of fact. So if it's a question of fact, you can't get summary judgment. Summary judgment is only when it's a matter of law and there are no questions for a jury to decide. So they say, despite the fact that the defendants failed to raise the workers' compensation law defense in their pleadings or bill of particulars, we agree with the defendants that the nursing home did not waive its reliance on that defense. And the affirmative defense of workers' compensation may be waived only by a defendant ignoring the issue to the point of final disposition itself. So even though they didn't raise it in their answer, they didn't raise it in their bill of particulars, they never even said that they were going to argue this, you could raise it at any time until the case is over, final disposition. And they give case law for that. So, and they rejected defendants' argument that they were entitled to summary judgment dismissing plaintiff's complaint against the nursing home because they said, look, these are triable issues of fact as to whether plaintiff was or was not a special employee of the nursing home. And those issues of fact must be resolved before either the plaintiff or the nursing home could be entitled to judgment as a matter of law with respect to each other. And based on this, they modified the judgment by denying plaintiff's motion for summary judgment with respect to the nursing home's liability and by vacating the award, the $3.9 million award against the nursing home. So they vacated that, that's gone. And they remitted it to the Supreme Court for further proceedings on the amended complaint as against Suburban. So I guess they have to do another trial, maybe only as to this issue as to whether she was a special employee. And now with respect to the trial, they rejected defendant's contention that the court erred in admitting in evidence a life care plan that had been prepared by a plaintiff by a registered nurse, because they said, look, a life care plan has to be based on the recommendations of treating physicians. But here it's been reviewed, discussed, and approved by the treating physician. So that's proper. And the court said the nursing home was fine. There's no problem with it. And they said the defendant's arguments with respect to the accuracy of the entries in the life care plan go to the weight to be given the life care plan, not its admissibility. So the life care plan is admissible, but how much weight do you want to give it? Do you want to give it a lot of weight? Like, if it's by a doctor, maybe you give it a lot of weight, or the way the entries are made, the way it's prepared, or if it's like really weak, it's just a nurse and it doesn't have the proper entries, okay, give it less weight, but that's up to the jury. The jury decides the fact. So it doesn't go to whether it's admissible or not, it goes to the weight. And then they also rejected defendants' arguments about the amounts for past and future pain and suffering, future medical expenses, future lost earnings. They said, contrary to defendants' contention, the award for past and future pain and suffering did not deviate materially from what would be reasonable compensation. Because personal injuries awards, especially those for pain and suffering, are not subject to precise quantification, we look to comparable cases to determine at what point an award deviates materially from what is considered reasonable compensation. So they're basically saying, here, look at this case, look at the testimony, look at the records admitted in evidence at trial. They established the plaintiff's injuries had a profound effect on her physical condition and her mental health. She had a brain injury, it's a serious, life-changing, forever injury. They said, look, the evidence strongly supports the determination that plaintiff sustained severe and permanent injuries to her neck and back. We conclude that the brain and neck injuries manifested themselves in objectively identifiable symptoms, justifying the awards for pain and for past and future pain and suffering. So they're saying, look, this is even objective. This isn't just somebody saying, oh, I have a brain injury, but they have no proof. You have proof here, you have medical proof. So they further said that the award of future medical expenses is supported by evidence because plaintiff presented competent proof of necessary, anticipated medical costs through several witnesses, probably the doctors, the life care plan, right, as well as her expert economist. So she had an expert economist. This is really good. See, this gives you like what you need to win a case. It's basically telling you, right? It's saying this is what you need to win a case. You need competent proof of necessary, anticipated medical costs through witnesses like doctors, economists, life care plan experts. And they said a jury award need not match the expert's assessment exactly, especially where the award was likely based on an age adjustment. Now, with respect to the award for future lost earnings, they again rejected the defendant's argument that the award was based on speculation and is not supported by the record on appeal. For a court to conclude as a matter of law that a jury verdict is not supported by sufficient evidence, it is necessary to first conclude. Now, these are the magic words after, conclude. This is what you need in order to, decide as a matter of law that a jury verdict is not supported by the evidence. Meaning, a jury gives a verdict, right? Say they give you $1 million, $10 million, and then the appellate court, would say that jury verdict is baloney. It's not supported by the evidence. Let's take that jury verdict, let's throw it in the garbage, right? This is what you need. You need to show that there's simply no valid line of reasoning and permissible inferences which could possibly lead rational people to the conclusion reached by the jury on the basis of the evidence presented at trial. So you have evidence presented at trial, right? You have medical records admitted into evidence, you have doctors testifying, you have witnesses testifying. There can be no valid line of reasoning, and you can't even make any permissible inferences. You can't infer from the evidence that could possibly lead any rational person to say, like this should be like a $4 million case, or this should be lost wages of $1 million. Based on the evidence presented. So that gives you, again, that's the standard. So that's why I like reading these decisions, because it tells you what you need to do to win cases. So it's not just about this case, it's about every case, right? Because this is the appellate division law. So not only did the proof at trial establish that plaintiff was unable to return to work to her former employment as a hospice aide, testimony and medical evidence established it was unlikely plaintiff would ever be able to have gainful employment due to the severity of her injuries. Plaintiffs and other witnesses testified concerning plaintiff's employment and income before the accident, her inability to function in the most rudimentary basic levels, and her loss of any potential earnings in the future. We thus, now this is the appellate division speaking, we thus conclude that the jury was presented with sufficient evidence about her present condition to reach a conclusion that plaintiff lacked any ability in the future to earn income via other types of employment. Therefore, we cannot conclude that the jury's verdict on future lost earnings was, quote, utterly irrational, unquote, or lacked sufficient evidentiary support. So they're basically saying, look, there's enough support. She couldn't work, not only as a hospice aide in this nursing home, she couldn't work anywhere. And everyone's saying she can't work anywhere. So how can you say that this verdict is utterly irrational? And that's the standard again. I guess they quote utterly irrational, and they cite to a case named Cohen, 45 New York 2nd. So anyway, that's the point, right? Now you know, hey, it's this standard about that I read earlier about, you know, no valid line of reasoning, and it's also the jury verdict has to be utterly irrational. It just has to be like not supported by the weight of the evidence or by the evidence. So that's why I like reading these decisions. Although, you know, I understand it might be a little too nerdy for some people, but I think it's helpful. It's helpful. It could be helpful for people that have their own case, because they could know, hey, this is what you need to prove in order to win the case. So I hope this has been helpful. Let us know what questions you have, but I think there's a lot of lessons to be learned from this case. Look, it's a good result overall, almost $4 million, $3,972,701. I think the future medical expenses, even though they had proof that it's 4.5 million, look, 2.5 million, that's a lot for future medicals. Lost wages, 1.1 million. You know, it seems a little light, like 177,000. So you're saying 200,000 over 6 years. So what is she making per year? Like only 30,000 about, on or about? You know, I'm not great with math, but what, 30, 35,000 a year? That's kind of light. But maybe that's what the salaries are all the way up there in Williamsville. So I would say, look, the future medical expenses were fine. The lost wages were fine. The pain and suffering, I really think, is low. For a brain injury like that, where you're using a walker for 3 years, then you're using a cane, and you have memory problems, you have involuntary jerking, and all of these horrific injuries, and all you're getting is 400,000. I mean, come on. Some cars cost more than 400,000. People are just buying them and racing them. You know, here in Florida, I've seen some Lamborghinis. I just don't think, you know, a life. Basically, you're saying a life is not worth more than 400,000. I think it's low, but you know, it is what it is. But let us know what you think. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families, and we are here for you. So I hope you like this video. Thank you for watching. Please like and subscribe to our channel. If you have a question, leave us a comment. We love interaction, and we're going to do a few lives soon. I'm back actually tomorrow night. I'm going to be back in New York, so the rest of the week we're going to do more videos, more lives, and you know, interact with everyone and try to help as many people as we can. Okay, have a great day, everybody. Bye-bye.